Of business law. Today we start a new area of law, or a new legal discipline. I hasten to add that over the next couple of weeks we will be working quite closely with regards to contract law. This is a very important area of law for many reasons, but in the scheme of things, what we're going to be looking at today is going to be the outset of understanding how a contract operates. And that's derived from an offer, acceptance, consideration, and the creation to create a legal relationship or a legal entity. And that's going to be the focus today. Obviously, everything we're covering today, as has been previously, will be part of the mid-class test, which takes place in week 6. But also everything that you see here and through weeks 1 through to today and as we go forward will also be inclusive within your exam at the end. And more on that when we come to that in week 6. So, today, the overview of the session is quite straightforward. I've got a weekly review and feedback, as we tend to do each week. It will be very much an introduction to law and its underpinning. I have to say this. I mean, contract law, I teach and have taught contract law in the law school. It's something that we run over 2 semesters. You're getting it over 2 weeks. So you're getting a bit of a condensed version, if that makes sense. It often can be quite complex, contract law. We can look at promissory estoppel as when you stop a contract. Again, we don't go into the kind of technicalities of that in this session, or indeed next week. But what we do have is a very good overview and a very good understanding and a grounding, and that really becomes critical for your pathway. So there'll be an introduction to contract law this morning, an underpinning of the law, and a research for the next session. Now, one of the things I'm going to say right from the outset with contract law is it does differ from employment law. Yeah, we have a contract of employment and we have contract law. You'll see when we talk about employment law the differentiation. So today we are looking at an engagement that, essentially what a contract is you enter into a promise to do something in return for another promise. And that goes back to Folks and Beer, which is an 18th century case. So let's plod on. Now, I did mention this already, just kind of get it fixed in there. Now, we're at week 4. So in 2 weeks' time, you will not be here. There is no lecture in 2 weeks' time. I mean, that's a bit of a... I thought I'd let you have a bit of a lie-in that morning, so I understand. We've got the class test will be taking place, I understand, at 3 p.m. Subject to confirmation, of course. And, of course, you will be informed. And I hope that this time next week, I will be able to tell you exactly where you are likely to be. But I can't guarantee that. Yeah. No, there'll be no seminar. There won't be anything before that lecture. Before the class test. But I will talk about it more detail next week, so don't worry too much today. But I think really the key of this, importance of this slide is really important. By now, you are entering into week 4. 4 chapters of the core textbook. 4 different exercises, both through Lucy Jones's book and through your current core textbook, where you can go and enter online and do these multiple choice test questions. You, of course, have got mine, which if you've come from a BTEC environment, the likelihood is your strengths may not be the same as those who've come down a traditional route where it's an A-level route. or a baccalaureate route for international students. So this is an opportunity for you to get a really good mark. And I say this with importance. You will be able to go into an exam with 50% taken care of and banked. And you'll know exactly what grade you have got. And then the rest will be down to you on the day on how you perform in the exam. So I cannot stress how important this is. And in reflection, often students will come back and think, you know what, if maybe I did better, could I have done better? Well, the answer is, of course, you can do as well as you engage in doing that process. But you can achieve 100%. Okay? The unfortunate thing is when you look at a multiple choice test question, in your case you will have 30. If you get one wrong, that percentile is quite high. Equally, if you get one right, it's quite high too. So it works both ways. So bear this in mind. And the revision guide, of course, as I've said to you last time, is on SurreyLearn. So from week 1, you will have known what this class test was going to be about. You'll have known where to go to get support. You will have known what questions to engage with and how to do it. And my advice is you need to be putting time aside every week, every day, and going through them for MCTs, and not because the answer feels right, looks right, or may be right, but is indeed right because you've identified the 3 wrong answers. And if you apply that approach, you should do rather well. Anyway, we'll reflect back on that later in today's session. So, additions. Now, obviously, this week, it's been a busy week. Some of you may have noted who are in here this morning, I have emailed certain students, of course, and I've made that quite clear from the outset, that I do contact students. And so, therefore, I'm keeping an eye on your attendance in a supportive, not punitive way, of course, but also to ensure that, obviously, we have continuity as we go forward. But also, what else has been going on this week? Well, we have the supportive digest of case law. And this was put up on Monday, so it's put up where are we? Wednesday, so it was 2 days ago. And the idea of this is quite straightforward. And I just want to go through it very briefly with you. It is online, and it holds importance, not because in the class test you must hold to book every one of these cases, much as I would like to do that. That isn't going to be the case, and there's no requirement, just so we'll pin that now. You don't have to know this inside and out for the class test, okay? As I say, with regards to case law in the class test, you need to bear in mind and be mindful of cases we have talked about. Okay? And that reflection will be regarding the class test. But this, on the other hand, is slightly different. Now, this is important. I'm a great believer that you need as many tools as you can to understand how law operates. And, you know, if I were to use a case of Order, Cleanse and Belcher, in Order, Cleanse and Belcher, it was an employment law case, and the judge needed to identify was there a contract of employment for or of services. So the judge decided in this case what was in the minds of the parties at the time they entered into the contract. Order, Cleanse and Belcher. So what we're doing is we're not actually explaining what the whole case is about. We're actually identifying the key aspects that are driven from that case. And we're in a common law jurisdiction with legislation and case law. So therefore, case law is absolutely critical. And when you're reading your core textbooks often guide you through the actual case itself. And what you need to be able to do is to extract that precedent. Okay? Why is that case so important? So in here, you'll see there are a list of many cases, all with regards to contract law. And what I've done is I've identified the case, the name of the case, and then I have given the extract of why it has importance. So if we take the first case, which is Craig and Malvern Fishing, negligence by a security firm was excluded by a limitation clause. So it meant that a limitation clause could exclude liability. And you could use that case to support and engage your reader further to show that you've got a very clear understanding of the case. And this will become really, really important from week 6 onwards. And it will become important from today because understanding contract law is really important. You see, there is no real legislation in contract law. There's some, but it's mainly driven by case law. And we're going to deal with some of that today. and it's understanding how consideration works. And from the outset, there may be those of you from other legal jurisdictions, and you'll understand outside of the legal jurisdictions, so European jurisdictions specifically, that it may well be that when you look at contract law, we will be introducing a new ingredient called consideration, which will not be present in your own legal jurisdiction, but it is present within the jurisdiction of England and Wales. But I'll guide you further on that. So, my advice is download this. It's a PDF. Have it handy. When you're reading through cases, you'll be able to identify the precedent of each of the cases, and it will support you as you go forward. Right, preparation for this week. Contract, well, okay, it's part 3 of the core text, and it's a big chapter, and it's quite interesting. Rather than breaking it up into chapters, it does it in parts, so it's much better you get an understanding of the overall part, and then you can then refer back to it. Please, my suggestion is use Lucy Jones as well. Contract law is probably, I say this, and it is going to be the case that actually, of course, you can use numerous contract books to support you, and case law and contract law is slightly different from tort law. It doesn't change that often, which is quite good. The only other area of law which is like that is land law and trusts. But there are cases, and indeed this morning, and I said to you last week, by the time we were in this lecture, like this time last week, there would be a material change, and I'm pleased to tell you, I've got one for you for contract law. So none of your core textbooks will be addressing a case that I'll be talking about shortly. So this really is an important area, and it's a very important area of your understanding and how it works, as it affects all of you in this room today, okay? Whereas tort law perhaps may not. Just on that note, before I go there, I've put Lucy Jones up here. I'm minded to say that, and I'm just going to come onto this because it's going to be important as we go forward. Lucy Jones, Lucy writes quite well. I know Lucy quite well, but the one thing about it is with her book which is different from our key core text of Marsden and Ferris, is the fact that Marsden and Ferris is kind of very in your face. This is the legislation. This is the case law. These are the principles. And sometimes they can be a bit tricky. Lucy Jones is slightly different. For a start, it really uses the use of colour, which it might be an odd thing to say, but it's a really important one because it's another driver, another focus on being able to help you understand and to be more lucid in this area. Now, typically, by week 4 now, things that we are doing, if you've attended all lectures, should be settling in, and by now you will start, within probably the next week or so, the penny will drop with regards to it. It's like learning a language. You learn a few phrases and it becomes quite hard to do that. And then once you've got those phrases to book, you then suddenly learn that you can just do other things. It's a bit like for those of you who drive a car. The first time you get in the car, maybe do it this way. The first time you're in a car. How many of you drive cars? Right, okay, lots of you, so we all appreciate this. First time you got in the car, you put that ignition on, you thought, oh, this is the car for me. I'm going to drive down the road. And at last, for all these years, you've been waiting for this car, so you get in there. It's a manual, not an automatic. So you're in this manual car, you're in there. You put the radio on nice and loud so the neighbours and the world can hear you. You get the key, you put it into the ignition, you slowly turn it. The car begins to purr. And you think, this is it. This is what I've been waiting for. I've got my wheels, I'm on the road, I haven't passed my test, but hey ho, who cares? I've got somebody in the car who has. And so I'm going to sit in this car and I'm there and you're just getting ready to drive. And as you do, you think this is so easy because you've seen it on television, you've seen it on films, and your friends drive, but they never tell you this. Right, now, disengage the clutch after you've put it into first gear and put your foot on the accelerator. And you think, oh, this is an easy piece of work. And guess what happens? The car stalls. It goes and stops. In my case, I broke my clutch. When I first did it, I thought this was not fair. This is not the way cars work. And it's a little bit like law. It's the same process because once you get akin to what you're doing, you don't worry about it. Your feet do all the work. You don't even think about it. I hasten to add, like law, if you think what your foot is doing, you can have an accident because you get used to that clutch movement, as I did when I rammed into the back of somebody, when I was thinking, I wonder what my feet really do when I'm driving the car. And then my feet really didn't know which was the brake and which was the clutch. So I put my foot on the clutch thinking it was the brake, and I visited a car that was in front of me. So these are really important assets to remember, because law is almost like this too. And it gets at, and you'll soon see, it's conjoined. So we're going to look at a case that's going to come up now which really demonstrates this, because you've just been looking at tort law. So a case regarded, or with regards to Barclays Bank. And it dealt with negligence, a duty of care. And there was an issue because there was a contract, and the contract existed between a customer of the bank and the bank itself. And the bank mismanaged a particular situation with regards to the handling of their case. And as such, there became a potential issue of two factors. One, there was a breach of a duty of care. Two, that there was a contractual obligation that the bank had and had underwritten, and because that contract had been broken, therefore a duty of care had also been breached too. And the reason why I'm saying and talking about this case, and it's up on Surrey Loan, so you can have a look at it, but why I'm saying this is because you need to understand that these components can link together. And if these components link together, you will see that in many cases, and we go back to our issue of paintballing, yes, you might enter into a contract with paintballing, but is there a duty of care that then follows as you go forward? So I put here, the jeweller sued his bank for a breach of contract and negligence. The claimant alleged that Barclays had assumed a responsibility by virtue of providing an account manager who knew the nature of the claimant's business and was aware of a specific transaction in case. What it meant was that this particular manager, although there was a transaction in place, didn't manage it effectively, and as a result, it meant that the jeweller attained a severe loss, a financial loss, which he blamed the bank for, because there was an obligation. Now, that's the kind of a sort of a bridge that links us from last week to this week, but we got a case which only came out last week. Well, let's be very clear so you understand this. This was by the Supreme Court, and in the Supreme Court, the judgment was given on the 13th of February. The case was heard on the 11th of October 2018. And then what happens is the court often has what we call reserve judgment. They hold back on their judgment until they've really looked at the case and they've written it through and they've looked at all the points, and then they come to a conclusion. Although the judgment itself tends to often be released a little earlier. But let's just have a quick look at this case. I put here, and this is really important for today, okay? A binding oral contract have been reached between the parties. That's between these two individual parties here. Despite there being no express identification of the event which would trigger the obligation for commission. This is to do in the estate agent and expecting commission. Now, what I'm going to do is I'm going to put this case online. And the reason why I brought this case to your attention this morning is because we're going to be talking about this magic kind of, I call it the fluffy word, it's called consideration. What was in the minds of the parties when they entered into the contract? Yeah, you can look at Autoclans and Belcher, but it's a kind of a similar thing because it's to do with the consideration. You enter into an agreement, there has to be consideration. If there is no consideration, there is no contract, there is no agreement. And what it said here was that the company, it had been heard in previous courts, this chap had entered into an agreement with a letting, or with estate agents rather than a letting, to engage in a property. And whilst no formal contracts had been signed, there had been an exchange of emails, there had been an exchange of agreement. And up until that point, the court had said, no, there was no contract. And the estate agent said, well, hang on, you know, we've got these communications which go backwards and forwards, which suggest there was an understanding and an engagement to carry this forward. And the party sought, to their advantage, said, well, you know, rather than the estate agent, the other party, well, we didn't sign anything, so therefore potentially there is no contract. And arguably that could be a persuasive position. Now, in banking, slightly different, because you've got consumer acts relating to banking if you borrow money. And if a bank doesn't follow those procedures, then obviously it can fail, or the contract can fail. This isn't to do with that. This is to do with offering a service. But the reason why I'm showing you this morning is twofold. One is because I do think this will make a potential material change in contract law as we go forward. It's quite an overwhelming statement which has happened because obviously it really relies on consideration. The second reason is it reinforces consideration, which is what we're going to be talking about this morning. And thirdly, it really brings home the importance of understanding how contract law operates. Now, on that note, I will be putting up the full judgment so you can read that. So you don't need to go on Westlaw, although Westlaw will, of course, have it. But here is the thing. On Westlaw, what we want to look at is you can look at the full judgment, which is okay, great, gives you a real clear understanding of what's going on in the case. But more importantly, what we can look at here is the case analysis. And for you this morning and going forward, the importance of this case analysis is the fact that not only does it give you a clear steerage as far as what the case is concerned in a very simplified way without having to really undertake and understand everything, all the facets that are going on. The really good part about all of this is the other cases it relies upon when it reaches its judgment. And those cases will be ones which you will be having to engage with between now and week 11. And certainly with regards to any exam, because they complement some of the cases we are going to be talking about. So there you go. All of that's going to be up on Surrey Learn, so please take an opportunity to have a read through that if you can. And again, consign those to your notes. Right. From the bookshelf. Now, from the bookshelf. Now, in week 1, I did talk about various different books, and I'm just going to give you a heads up. There are some slightly smaller books rather than the core textbooks that I've referred you to. And these are, well, the first one I've got here is Contract Law, which is Key Cases. Deals with all the key cases in relation to contract law, but in a very simplified way with lots of diagrams, which I think is quite good, and we'll come on to more about that when we hit week 7 and week 8. But more importantly, these books will really help support, underpin your understanding of cases. Because rather than talking about them in big detail as per your core textbook, it does it in a very simplified way. And when it goes to exam time, you'll find that they will be immensely useful. And my recommendation is don't go out and buy them. Go over to the library and go and have a look at how they operate. And does that work with your style of learning? So, Nutshells talks about all the principal areas of law, and it deals with maybe tort, contract law. We, of course, will be doing employment law as well. And then we have nutshells and nut cases. So nut cases would be all to do with the case law rather than the principles and the areas of law. Whereas, of course, the other book is very much kind of a combination of both. So have a look, go across to the law section in the library and just see what they've got. So let's make a start then, I think, on where we are. Now, with this, again, have a read through the list of the cases. These will help you in accordance with your core textbook. And there, of course, you can download that on Surrey Learn. Now, what is a contract? What is a contract? Who'd like to tell me what they think a contract is? How many of you have never signed a contract? Oh, good. I'm glad we're all in agreement there, because that's absolutely correct. You've all engaged in a contract. How many of you, I'll tell you what, have a quick chat with the person next to you, as always. If you don't know who they are, please introduce yourself first. And then just say, this morning, did you engage in a contract? If so, what contract did you engage in? All right? So if you don't know who they are, next to you, introduce yourself. Away you go. You've got about a minute and a half to talk. If you have a chat with the people behind you, that would be absolutely super. Okay, time's up. So, can anyone tell me, did anyone engage in a contract this morning? If they did, can anyone tell me what contract they engaged with? Yes?
It was contract.
Your housing contract. Okay, there was a bit of intrepidation there with the housing contract. I think there always is. Was it a tenancy agreement?
Yes.
Oh, right. Yeah, that makes it even worse. Yeah. 1 foot stage back. Yes. No, tenancy agreements. How many of you have got tenancy agreements? Oh, yes, they're horrendous things, the tenancy agreements. Especially, my daughter, she said, well, Dad, you're a lawyer. I said, yes. She said, I've got a problem. Oh, yes, and what's that? I said, well, you know, I looked at that flat, and I said, yes. I said, well, I really liked it. You know that, didn't you? I said, yes. Well, I had a word with the housing company. I've engaged in a tenancy agreement. Well, that's good. Yeah, but Dad, yes. Here's the other thing. I was with some friends, and you know, I really thought long and hard about this, and I actually preferred another property. So guess what I did, Dad? I said, you're not going to want to tell me what I think you've just done. Yeah, I entered into another tenancy agreement. I said, so you've got 2 tenancy agreements? Yes. Well, you know that you're legally responsible and bound under that legal obligation for payment for part thereof and full part thereof of all monies from the date you signed it until the date it concludes. Did you know that? It's all right, Dad, you're paying for it. Okay, so yeah, you have to be very careful about these things. And of course, tenancy agreements, we all know, can be one of the hardest things that we get ourselves involved in. And also, it can be, you know, and obviously they should be operating in a particular way. Good news on that was we did manage to remove one of the tenancy agreement. But there you go. That was more by luck than by judgment. So, a contract, well done. That's a really good start. Thank you for that. A tenancy agreement is and a contract. And we, of course, we all engage in contracts all the time. Anyone else get engaged in a contract this morning?
I don't know if this is right, but I was told buying things is considered a contract because you exchange money for it and then you have a certain amount of agreement.
Okay, so you bought something this morning?
Yes.
Okay, you entered into a contract. What did you buy this morning?
I bought a cup to put my lemons in.
You bought a caviar. Good, okay. Well, yes, anytime you exchange a promise, you engage in buying something, you've entered into a contract. In fact, if you've got the bus here, you entered into a contract. If you parked in the car park, you entered into a contract. By the virtue of you being at university this morning, you have entered into the contract and you are now engaged in your performance of that contract. Good. Look, a contract is it's established through common law. Okay, so we now know what a contract is. What is common law? We talked about this week 1, we talked about it week 2, we talked about it week 3, and we're now at week 4. What is common law? Anyone? Yes. Case law, good. Case law and legislation can be deemed common law. The reason why we tend to focus more on case law is because we deal with areas which focuses on how it turns and how it operates. And obviously, if we're in criminal law, we perhaps more be minded across the legislative areas. Good, so it's engaging. So if we are engaged in civil law, and we've engaged in a contract, and we know that we are engaged with the performance of that, and it goes wrong, which court would we start off by going to? Have a quick chat with somebody next to you. Just what's your starting court? Okay. Can I have somebody from this side? Where is your starting point? Which court might you start in? It's all right, you've only got a class test coming up in 2 weeks' time. You'll be all right, don't worry. It's not a problem. We'll hold on to things. Okay, anyone at all? Okay, what about the middle group? Come on now. Anyone can tell me where would your court start with, potentially, in a civil claim? Well done, absolutely right. You're really probably looking at a county court. Remember, we're dealing with contract and we're dealing with a situation of a claim and non-payment. So we're probably looking at county court. Good. We might go to high court, but probably for other matters, probably family matters, pecuniary matters. You know, for instance, you don't pay your tax, you go to the high courts, all right? Good. So a contract is an agreement which gives rise to obligations and is enforceable by law. Okay, let's be really basic about this. A contract is about, I promise you and you promise me. And we have a bilateral and a unilateral contract. Hold on to those two words. We are going to talk about them this morning. And it's important you understand how they operate, because they operate in a way which may affect how the contract may operate. And we'll engage in that. So it's an agreement which gives rise. And it means that, why is it gives rise to courts and enforced by the law? Because the courts will be looking at equitable remedy. That means a remedy which is fair in its outcome. And therefore, in order for it to be fair, it will look at the contract and it will then seek to make a decision as to whether the contract is binding or not binding. That means it is either enforceable or it is not enforceable. So, we said what is a contract? Well, we know we've entered a tenancy agreement. We've been to the shops this morning. And we've got lots of other things which have gone on. And you're all here at university this morning. So, it's an existence of a contract entitles parties to legal rights. A legal remedy. That's what we're looking at. So a contract is enforceable by the courts, and it seeks to do just that. So when do we enter into a contract? Well, we're going to be talking about that this morning. We enter into a contract all the time. Sometimes we unwittingly enter into it. So for instance, you could park in a car park, not realise that there is a display or information which says that you, in order to park your car here, you have to carry out a certain type of action, and if you choose not to do that, you may have to suffer the consequences. Okay, that's just as a by the way. So the key things here are, what are the elements that go into the mix, this form of contract? And this is really essentially what we're going to be talking about this morning. And this is what you've got to really hold on to, because these three magic ingredients are what make a contract. Okay? It's really important. So, an agreement. An offer is made. Then the other party, we have the offeree to the offerer, we have the other party who will then apply consideration, whether to enter into that contract. And that consideration is binding. So the case that we're talking about this morning, it was irrespective of any forms being signed, it was the fact that the court identified consideration applied within that contract and therefore held it to be binding. And then there is a third part, an intention to create a legal relationship. And we're going to examine that this morning as to how and where we can enter into legal agreements. And it's important that intention is there. Yes?
I just have a question. So, what if you enter a psychological contract with your employer? Is he legally obliged to fulfill your needs?
Okay, I will talk about that when we come to our employment, but don't worry, there will be matters that we'll be talking about today. It's a good question, though, and I like that, and there will be plenty of time to discuss that, so don't worry. But the intention to create this legal contract is really important. And the fact is that you are making a commitment to do so. But bear in mind, in some areas, such as banking, there are legislation which applies where a bank and an individual has to comply with. And if they don't, then it can nullify that contract. All right? So it's slightly different. So, a contract overview. So here is an overview of a contract. Right, from the outset, we start off by the formation of that contract. How did that contract come into being? Then we look at the terms that surround that contract. And those terms would be agreed by both parties. And those terms would be part of that consideration. Then we look at discharge of the contract. That means, how does that contract come to an end? Does it come to an end because one party fails to perform their obligations, or does it come to an end because that contract has reached its natural end? And if it hasn't reached its natural end, but it's a situation that one of the parties have failed to engage with their responsibilities under that contract and obligations, then we then look at the remedies. And the courts will look at, as we will see over the course of the next few weeks, that essentially the courts will seek to put the person or parties back into the position they would have been had the contract not been breached or broken. That's an important thing to hang on to, okay? So that's kind of our outset where we will be looking at things. So, How can a contract be defined? Well, I've already said it's an agreement, and I've already said to you it's enforceable by the courts. So I put here an agreement enforceable by the law between two or more persons to do or abstain, that means not do something, or doing some acts or acts, their intention being to create a legal relations and not merely to exchange mutual promises. Now, I have a diagram which I'm going to make reference to later on, which I've put up on SoReLearn for you this morning, and it's an important one because it gives you an understanding of how consideration operates. And a part of that consideration will redress some of these issues that we're looking at here when we're talking about exchanging of mutual promises. So if I, and again, I will go through this in a little bit more depth shortly as to how you understand how this contract operates. So a simple contract can be made in writing, orally, by implication, or by performance. So you don't have to have a written contract. And that, in fact, that case this morning demonstrated that the courts really made that the position. You don't have to have this written contract. If there's an agreement and there's consideration and there's an intention to create a legal relationship, then by virtue of that alone, there is a contract. It can be made in writing, which is the obvious way. It can be done orally, but that becomes a little more difficult to prove because you've got to make clear that the parties did actually agree to enter into this contract, but it can be done that way. By implication, implying that if a party engages into a contract or other parties do, they form part of that contract, and then by performance. I'll give you an example, and I just talk about about employment law as an example. When we look at a contract of employment, I often hear, oh, well, look, I didn't sign my contract of employment, therefore, they can't hold me to rights. They can't bang nobody to rights on this. It's quite okay. I didn't sign it. Did you? Oh, well, you're going to be... No. Your performance. Did you arrive in at 9 o'clock that morning? Did you engage in the work? Have you performed under that contract? If you have, by virtue of your actions, performance would suggest you have consideration, you've entered and you've engaged in that contract. So, I've also put some contracts, however, can be made in writing, e.g. credit or by deed. So if you enter into a credit card, you can't just say to the bank, oh, I'd like a credit card, please. And the bank says, oh, yes, there you go, have this credit card on us. Go away and spend some money. And by the way, what we might do is on a weekly / monthly basis, let you know how much you owe us. No, you have to actually agree under the Consumer Credit Act on this. If you have a deed of property, it's another type of contract, but they are ones that require an undertaking which will engage for a deed, which is property or land or conveyancing of property. That is undertaken by a solicitor, and of course you have to have legal assistance on doing it. It's not something you can engage in outside of that. But deeds are another form, so conveyance of land or obtaining credit. These are written ones, and they have to be made in writing. So we have our contract. And really, what we're going to start off with now is understanding how a contract operates in its simplest form. And we have what we call offer and acceptance. So, the party making the offer is called the offeror. And it's important you hold on to these names. They are the offeror. And the person to whom the offer is made is called the offeree. So, I have my glass or bottle of water here. And I'm making an offer to you, so I am the offeror. You are making a decision at this point. You haven't said yes because I'm selling it for £50. It's a great bottle of water, by the way. I'll let you think on this. You are the offeree, and you are considering this at the moment. So this becomes our consideration. So we have our bottle of water. So we have, if you remember, just a few minutes ago, I talked about a unilateral and bilateral contract. Well, in a unilateral contract, the offerer, which would be me, states the offeree, if you do something, I promise to do something in return. Okay? Or a bilateral contract is where both parties have obligation, which is actually where we're coming to here. So we would be looking at a bilateral contract, which would be agree to purchase a car from B. In this case, it's a bottle of water. And so we have two types of contracts. So one is that you've got to go and do something, and when you've done it, then there is a commitment by the other party to promise to recompense or to resolve those actions which have taken place. There's a promise to do something in return, or effectively something which is straightforward. Now, I mean, again, a lot of things we're engaged in are on bilateral contracts in that respect, where you are promising doing one thing in return for something else. So a bilateral contract is probably the most single enforceable contract. We see it everywhere. You know, you go to a drinks machine. You actually enter into a contract with a drinks machine. When you go to a drinks machine in the morning, you probably didn't realise this. You go in, you go your 50p, and you put that 50p in the machine. Your consideration is putting the 50 pence in that machine, and you enter into a contract. If the machine doesn't give you the drink, then they're in breach of contract. Okay? So, and then you have to look at a remedy, a suitable remedy, as to how you get round this. So, offers can be made orally, in writing, or by conduct. And we have Robertson and Anderson. And this deals with an oral agreement, but arguably, the position of whether a contract was enforceable was, did either or both parties conduct themselves by performance in this contract? So, you know, if it was an oral contract, you know, so, you know, it would be like if I said, look, it's so warm this February, I've got this great deal with a local farm, and I can offer you a job this morning. Not a real job, I hasten to add. This is just an exercise, so don't get excited. We can go berry picking at the local farm for wine. That's exciting. And as a result, I can pay you £8 an hour to come with me now. Now, that would be an oral contract, okay? And it would be a contract which would be operated on your and on the measure. So we'll just go back to our previous slide. So it shows it would be a unilateral contract, because I would say to you, you come with me, we're going to go and do this, and once you've committed yourself to doing the work, when you have paid the work, so as you would do in a job, I promise to pay you in return. And arguably, when we're looking at Robertson and Anderson, it's a question of whether or not the parties had actually fully committed to engaging in that contract. So the offeree must have the knowledge of the offerer from the offeror. Okay, so if I say to you, I'll tell you what, I'm going to put that there, and if anyone wants to buy it, it's for £50. And I make the assumption, oh, you've seen it there, you're going to buy it. No, there has to be clear knowledge. It must be communicated effectively between both parties. So I put up here what happens in the case where somebody seeks a reward for returning lost cats. And I put here the example can be drawn from Taylor and Laird, where a ship's captain formally resigns and then assists his crew on returning a journey. In this particular case, the case was that the captain was engaged with this particular firm. Oh, no, not firm, sorry, it was with the ship. And he decided to resign his position. But he stayed with the ship and supported the sailors to come back. And then he sought to be paid for his work. And the company said, no, because you resigned. You resigned your captaincy. Therefore, we're under no obligation to pay you. There is no contractual obligation. Whether you chose to do something, that's entirely up to you. But you did it without our knowledge or our agreement or our consideration. So therefore, there's no contract. So the offeree must have knowledge of the offer. So if the terms of the agreement are meaningless, then the court may ignore them. Now, this is really important. When you enter into a contract, sometimes you'll get contracts which have words in them which actually are spurious. They don't really have any sense. Okay? When we look at express terms and implied terms, and we talk about this a lot in employment law, but when we look at, with contracts, if we're looking at an express term, it's a written term which is agreed between the parties, and then both parties are in agreement to operate under those terms. So if you go and you buy, buy something or a product, or you're engaging in a service, you'll enter into terms of that service. You know, like that comment that I made last week, that EULA contract that you see when you enter into Facebook, that you've all read that 60 pages, you've agreed that you're going to abide by certain things. But the thing about it is that in this case here, in Nicolene and Simmons, it said that usual conditions will apply. And it was a term that was given in the contract, and the court said, well, that's meaningless. What are usual conditions? Quantify, usual conditions may apply. You can't. It's subjective, not objective. So the courts will make their own interpretation. And that's when we look at an implied term. An implied term is when the courts may seek to find a term in a contract which isn't written and may infer that a term within that contract may exist. But what's important here is that you cannot have something which is vague. And when we look at the Consumer Rights Act 2015 with products and services, it's really important that it's clear, it's transparent, and both parties know from the outside what they're engaging into. If a term within the contract is central and is meaningless, then the contract can fail. If you've written something which is meaningless, and the whole contract turns on this, then that contract may fail. And then we have the case of Carlyle and Carbolic Smokeball Limited, which talks about you're not making a contract with the world. Okay, this is talking about an invitation to treat, which is a separate thing which we're going to come on to in a second. So you can't make a contract with the world. It's got to be between individual parties. All right. Now there are exceptions to the rule here, and we'll talk about those this morning. But by and large, the contracts are often between two parties. And all parties in a contract must have knowledge that that contract exists. So let's be very clear how we're looking at things. So first of all, we have, and I'll just come back to this slide in a second. We'll stick with the offer. I have my bottle of water. Bottle of water is there. If somebody wants to purchase that, or because I come up with an offer and I say, well, I'm selling this bottle of water for 50 pence. At the moment, nobody has entered into this contract. So from the outset, there has to be an offer. You look at the bottle of water and you think, actually, this is for me. I'm really thirsty at the moment. I need this to stop me falling asleep in my lecture. I'm not for a moment asserting that's the case at all. But let's imagine that it were. It had some vigour that will keep you alive in my lectures. And you're thinking, oh, great. So you say, yeah, okay, I'd like that. So your consideration then is of acceptance. If you then say, I accept, we've had our consideration, acceptance. We now go to intention to create a legal binding agreement. And that's it. So then, if then somebody said, oh, I want it, but no, actually I don't want it, I can say, yes, but we entered into an oral agreement. It is binding. And you are now in breach of my contract. I will be looking at damages accordingly. Obviously, they will be limited, but you know what I mean. The point I'm making here is that this is how simple a contract is, but it has these three ingredients. And it's really important that you understand that. Now, as well as a contract, we have an invitation to treat. And an invitation to treat is incredibly important because often when we see things, we think that there is an offer. There is a, when we go past a shop window and we look at the window and it says, buy one, get one free, for argument's sake. Or it might say, or we might pick up a newspaper and we see an advert. Or alternatively, we might watch television and we see an advert. These are what we call invitations to treat. They are not offers. These are not about engaging into a contract. All right? And I'll explain how these work and what they are. And this is incredibly important. So, an agreement, as we've already said, is there must be an offer, consideration, acceptance, intent, a legal agreement. That's a contract. So, so what we have here is an offer on one side, and I've got an invitation to treat on the other. So, in an offer, you're bound by specific terms. So when you enter into that contract, you're bound by the terms of that contract. They must be clear. They must be certain. They must not be ambiguous. They must be clear and certain. They must be open for acceptance by another party. And they cannot be an ITT, an invitation to treat, which is something very different, which is what we're going to look at. An invitation to treat is an enticement. It's a negotiation. And it's not an acceptance. Okay? And it can't be accepted. You've got to go through the formal process. So, an invitation to treat is advertisements, display of goods for sale, auctions, statements of price. And I will go through all of these with you so you're very clear. So, if you have an offer, you've got consideration and acceptance, you have an agreement, okay? And you can enter into a contract. But if you have an invitation to treat, minus the offer, but you have an acceptance, there is no agreement. And what we're going to do is we're going to look at cases to show you how this operates. So, an invitation to treat plus an offer plus acceptance is good. There is an agreement, and it becomes legally binding. So, Pharmaceutical Society and Boots. Now, this is a really good case. And I've put here, in its short term, a display of drugs to open shelves. Let me explain. Somebody went into the shop, they got the drugs, they were given drugs over by the counter by the individual or the shop hand. They took the drugs, and they were told that they'd engaged into a contract. And they said, well, so the courts had to define, where is that contract made? Interesting, if you go into a shop, let's broaden it. I go to the shop, I go into my local Shops R Us in Guildford. We all know it, we've all been there. I'll pick up my bottle of water from Shops R Us. Have I entered into a contract? No. You see, I'm engaged in understanding that I want this bottle of water, but the courts have to determine, where is this bottle of water? Where do I fix that contract? When I have that consideration, when is consideration met? And it's met at the till. And at the till, it's offer, consideration, acceptance, enter into an agreement. Now, anything between that period can actually change. And that's what this case was all about. And it said that actually the display of drugs to open shelves was an inducement. It induced somebody to say, oh, would you like to buy this? It was an invitation to treat. It's an inducement. Not an offer, an inducement. And it wasn't capable of formulating a contract between the parties. We have Fisher and Bell, slightly different case. This is about a flick knife. Now, flick knives have been outlawed for many years. And a police officer was walking past this shop, and he saw this shop window, and in this shop window was a flick knife. And it said, this flick knife is for sale for X amount of money. So the police officer went in, cautioned the shopkeeper, and brought the matter to court, because it was deemed that he was committing an offence for selling a flick knife. And the shop owner said, I'm not selling the flick knife. The flick knife is merely an invitation to treat. It might have an offer there, but it only becomes a contract when somebody comes in, accepts the offer, and purchases it. The fact it's on display is not an offence. The offence is the sale of that knife, and that sale hasn't happened. So the court said, no, you're correct. It is an invitation to treat. So it was held that this item was an invitation to treat, despite the individual knowing that selling it would be an offence under the Restrictive Offensive Weapons Act of 1954. So what about an auction? And an auction is quite an interesting proposition. We see it all on television now. And British Car Auctions and Right really identified this. And it said, auction is an invitation to treat. You see all the goods that are there, and auctioneers are not guilty of selling an unroadworthy car. It's simply an invitation to treat. In this case, they were selling a car. It was unroadworthy. And so it was deemed that they were trying to sell it and therefore engage in a contract. And they said, no. And the court said, no, it's not. It's an invitation to treat. Holding an auction is an invitation to treat, just like walking past a shop and seeing goods in a shop window or seeing advertising. Now, of course, one thing you might be thinking in your mind now as well, if I purchase something from a shop, and we've got the Consumer Rights Act, because you told us about that last week, and with there are other consumer legislation, might that have an effect? And the answer is yes, it will have an effect. But if we're going down to the real core and the nitty-gritty of all of this, it is about whether or not matters are an invitation to treat, or whether there's an offer or there is not an offer. Is there a contract or not a contract? So it was deemed that holding an auction is an invitation to treat. Bidding on goods, when somebody puts up their paddle and they put their paddle in the air, that's a bid. That's an offer. So it's gone from an invitation to treat to an offer. If you ever go to an auction, in fact, you don't have a paddle, don't put your hand in the air, don't scratch your head, because you might suddenly find you've bought something without even realising it, because there's a code of conduct you've got to go through when you go into one of these things. So the position is quite straightforward. You bid on the goods, you're making an offer. When the hammer falls, that's the acceptance of the offer. And at that point, there is an intention to create a legal agreement. So you can go along to an auction, you can pry through things, there's no obligation to buy anything, there's no required of acceptance, only at the point when you engage in putting your hand in the air or your paddle in the air will that change. And then, of course, it may be that you are not the bidder that wins it, so therefore there is no obligation. So when a new bidder comes in, it changes that relationship. So what about adverts in a paper? Partridge and Crittenden. If you look at an advert in the paper, it is an invitation to treat. It is not an offer. It is something to induce you to buy something. But you cannot force that person to sell it at that point. I can give you examples of this. We've seen it, and there was a huge outcry. I remember probably about 3 or 4 years ago, or a bit longer than that actually, about 4, 5, 6 years ago, I think it was Tesco's, or a leading brand like Tesco's, I'm fairly sure it was Tesco's, on their website, they put a big widescreen television, the latest one, for £100. Now clearly they had made a mistake, and they would put this on there, and everyone's going, oh, I'm buying one of those. I've accepted it, do it, etc., and so forth. And the court said, well, actually, it's an invitation to treat. Clearly the information's wrong. Clearly you would have known from the outset, would you have bought a television, the leading television, for £100? The answer is no, you would not. And you were trying to potentially capitalise on something. So the courts can look at it in a very different way. And well, having said that, we often sometimes see a deal which could be true, could be a good deal, and actually the courts perhaps may not engage in it, but the company will accept those offers. So it really just depends, and we see this quite a bit now. And with the internet, of course, it's a slightly different proposition. But with Partridge and Crittenden, there was no internet. And basically this was very, very clear cut. If there is an advert in a paper, it is merely an invitation to treat. There has to be an offer and acceptance for there then to be a contract and to engage in that contract to make that a legal agreement. In this case, it was selling birds, and you couldn't sell these birds because they were protected. So the case fell at the hurdle in going into court because the court said there could be no offer and acceptance. It was an invitation to treat. Now, an exception to the advert rule. We have Carlyle and Carbolic Smoke Ball. Now, this is a very, very famous case. And this actual ad you're seeing here now is the ad that was actually published on or around circa 1890. And basically what it was, influenza, I suppose influenza is a bit like today's modern flu, but of course we didn't have the antibiotics. People died of influenza fairly, it was a terrible surge. And this particular case created the invitation to treat, I say. It's probably our starting point, so I'm going to guide you through it. The Carbolic Smoke Ball Company advertised a product during an influenza epidemic as being able to stave off the flu, because that's essentially what influenza is. And it said, if anybody used their smoke ball in accordance with the printed instructions and they caught flu, they would pay the individual £100. Now, at the moment, this is all an invitation to treat, okay, because it's an advert. And to show their good faith, what the company decided to do is they got their money and they thought, what we'll do is we'll put money into the bank just to show we're being good faith about this. And they put this in this ad. Now, Mrs. Cahill caught flu or influenza and used this product. And basically what you do is you put this thing, you hang this thing up and it smokes. And this smoke would come off. And this smoke was meant to help you breathe better, and it was meant to stave off catching the flu or the influenza. And she caught flu. And she went back to the company and said, right, I've used your product. I want £100, please. And the company said, no. Look, the advert was an invitation to treat. There was no offer. You bought the product, but it was an invitation to treat. The statement we gave was an invitation to treat. And so it went to court. And the court said, okay, you put the offer. No, there was no offer. It was an invitation to treat. But the point you put, the £100 that you had deposited, you had used consideration and you had now made an offer which was confirmed in that advert. So actually, now you had made an offer. So anybody who purchased that, by virtue of you putting money into an account, meant that you were putting forward an offer. You had consideration, and somebody who engaged with that could say to you, you then had an intention to create a legal agreement, and a binding one. And the court then said they were duty bound to make that payment. And that's probably the real first test of an invitation to treat with something which was being advertised. So when we look at invitations to treat, that's one aspect. Another aspect where we might get confused when we're looking at a contract and have we entered into one is a mere statement of price. And in the case of Clifton and Palumbo, a letter stated, "I am prepared to sell my Lytham estate for £600,000. It's a statement. It's a mere statement. And somebody said, "Oh, right, well, there you go. There's your £600. Can I have the estate, please?" I said, "Well, no. I made a statement. I didn't make an offer. I may be prepared to do this." It's merely a statement. And mere statements are not considered as an offer. It's a preliminary statement as to price. It's identifying what the price of that may be. You have to have more details on this. So, methods of how you would terminate the offer. Well, first of all, straightforward, you reject the offer. So, if I say, "Here's my bottle of water, I'm selling it for X," and somebody says, "Would you like the water?" Immediately, there's a rejection. No, thank you. Rejection. That offer is dead. But the minute that point that somebody has consideration and says yes, then there is an engagement. Now, we will look at these in a little bit of detail. But we also have what we call the counter-offer. And the counter-offer is if I say, "I am looking to sell my water, but I'm just going to keep that quite a bland thing, and I'm looking at a price," and I say to you, "Well, I think, well, let's do it this way. I'll do it slightly different way. I have my water here, and I come over to you and I say, 'Oh, would you like to buy my water for 50p?' And you say, 'No, thank you. No, I think, no, it's not for me.' And then you say, 'Oh, I will, but I'll buy it for £1. I go, 'Well, that sounds good.' I say, 'Good.' And then you come back and say, 'Well, hang on, no, I want to buy that water again, but I want to buy it at 50p because you made that offer to me.' So, my offer to you is 50p. You say no, the offer is dead. No consideration, no offer. You've made a counter offer because you've gone, 'Oh, well, I'll buy it for £1. So there's an offer. It's come from yourself now. My consideration is acceptance. Yes, please. Intention to create a legal agreement. Binding. So counter offers can happen and they can move. We've got a question on that which we will address later on this morning. There may be conditional acceptance, i.e. there may be conditions which may be imposed on that offer that parties have to engage with in order to use the services or use that product. You see it in most things you do on a computer and you purchase it, whether it's Spotify, iTunes, somewhere where you actually got a transfer of money. It could be Facebook in some respects, where you may engage in advertising. There would be a conditional acceptance based on conditions that go there and they may change. Revocation before acceptance. If you don't accept something, you revoke that offer, it can kill that offer. A lapse of time may kill the offer. And that can be either expressed or implied. And we do see a lapse of time when it can affect financial dealings. So, ending our offer. Offeror withdraws the offer is known as revocation. So hold on to that. If you withdraw an offer, it's known as revocation. And we've got the case of Payne and Cave and Dickens and Dodds. And we also know there are other mechanisms that we can engage in as well. And we've got postal rules. Now, this week, I put up on Surrey Learn for you quite a comprehensive little document, I felt. And it talks about offer and acceptance. And not only does it talk about offer and acceptance, but it also talks about the postal rules. Postal rules are really important because how they operate means that if I post something regarding an acceptance, acceptance is deemed when that communication is sent in that letterbox. okay? Not when the person receives it. Interestingly, we see the same sort of approach with the courts. If the courts write to you, the fact you've not received something is irrelevant. The fact that the courts have posted it to your address, and it's been the correct address, is sufficient. So the postal rules are also very important. We've got cases of fax, and we've got cases in relation to email. Email is slightly different. The courts they will look at behaviour of the parties that was intended, and they may come up with including and making some decision as to whether a contract exists. But, you know, our primary facie case law doesn't surround emails. It surrounds either post or, broadly speaking, the entering into of a contract. So, please have a look through that document with regards to the postal rules. We have Errington and Errington, a unilateral offer and acceptance and an intention to create legal relations. So when we talk about this engaging into a contract, it is very much about offer, acceptance and intention to create a legal relationship. And in a unilateral contract, where the offerer states to the offeree, if you do something, I promise to do something in return. It's not the usual one that we tend to do. Okay, we have a bilateral contract, which tends to be the most obvious one used. So, a key case on this, Williams and Cardwine. So, when an offeree has started to perform the requested act, they may not be able to revoke that offer. So, for instance, in this case, I've lost my dog, and I put up a reward for this dog, and the dog, anyone finds my dog, then I will pay that reward. That's what it's saying. It's a unilateral contract in one respect, in the fact that if somebody accepts it, their intention then carries out and they find that dog and then they bring it back. So let's say, well, let's go through this whole process. I'm out, I see a sign. Tiddles has gone missing. Tiddles. And a reward of £1,000 if you can find Tiddles. So I take Tiddles, I go for a walk, and I see this dog in front. I think that looks like Tiddles, and I look at this dog, and it's got a little name on it that says Tiddles. So I pick it up. I think, gosh, that's the same one. I go and knock on the door, and I say to the person, "Listen, I found your dog." Oh, and they say, "Well, you know what? I lost Tiddles weeks ago. I've bought another dog now. I don't want it, but you can keep Tiddles." You say, "Well, hang on. No, we've engaged in a unilateral contract here. You made the offer. My consideration was to accept it, and I found it. Now you are duty bound to pay me the money." But what about if the situation were different? I was walking down the road. And I'm going to ask you this question, so hang on to these thoughts very carefully. I'm walking down the road, and I see this dog. Oh, dear. Pick it up. Tiddles. All right, okay. Well, Tiddles, you've got a number on there. All right, okay. All right. So I pick up my phone. Oh, by the way, you got a dog called Tiddles? Yes. Oh, we lost it. Oh, well, I found it. Have you? Yes. Please bring it round. Where do you live? Oh, didn't you see the poster? Poster? What? Oh, never mind, but give me your address. So I go round. I arrive at the house. Hello? I've got Tiddles. Oh, you found Tiddles. Oh, you're so good. I had a reward for Tiddles, £1,000. Have you? So my legal Eagle Beagles, can I claim that reward? Have a quick chat with somebody who's sitting next to you and tell me, can I claim that reward or can't I? Okay, so Can I have a show of hands? How many of you think you don't have to pay? How many of you think you do have to pay for tiddles? How many of you are really not sure, in a real dilemma now? Do I ask for £1,000 or not? Okay. All right. Okay. Well, it's an interesting dilemma. But the reality is, think back to what we've talked about when we started. You have to go into a contract with knowledge. You can't go into a contract without knowledge. So our starting point then is, well, there's a counter argument. Well, you found tiddles and there was a contract and you've provided the dog back. Well, contract law states you must have knowledge in order to enter into a contract, because if you don't have knowledge, you can't have consideration. So the fact could be you knocked on the door and you say, and here's Tiddles. You said, oh, I had a reward for Tiddles. Really? Yes, I was going to pay £1,000. But thankfully, you didn't see that reward, did you? No. And you bought Tiddles, didn't you? Yes. Thank you. Bye. That's the reality, because there's no obligation to pay it, because there's no consideration. Okay? And the contract itself is a unilateral one, but that hasn't been performed. They didn't have knowledge of doing something before they entered into doing it, and therefore had consideration and executed it. So it's really important that you understand that process. And again, we've got questions on that when we come to our second part. Again, when we see an offer ending, we can talk about this, and we've already done it, but it's the counter offer. So if a counter offer is accepted, it nullifies the previous offer. So if you had put forward an offer, and again, you can arguably look at, let's go back to our auction room scenario, when you have counter offers which work in a slightly different way. When you start off and going, right, okay, we've got this bottle of water, I start the bidding at £15 because it's got air in it. That reminds me of a story. Very clever students were in need of topping up their grants a few years ago. And this is a true story. And what they decided to do was they got bottles, empty bottles, and they had clean air around them. Well, yeah. How do you qualify clean air? I have no idea how you do this. But what they did, they got the bottle and they went clean air, £15. And they sold bottle after bottle after bottle. And most of these, I have to say, went overseas. So there you go. You see, you can actually make money out of a bottle, believe it or not. And they did sell it to audiences overseas, which lived in smog areas. And they would obviously go, oh, that's better. I feel better now. I can go out and do things. So I come up with this counter-offer business. So you can be profitable even on the most basic of things. So on a counter-offer, we see in an auction, how this works is, of course, I sell this bottle of air, or in this case water, for 50 pence, and then another one says, well, okay, 50, do I hear £1, £1.50, 1, 2? So you've got counter-offers happening all the time. And every time a counter-offer comes, that original offer has been nullified. Okay, so nobody can go back and say, oh yeah, but I offered you £1, and it's now gone up to £15. So a counter-offer, you must understand, that final offer can be there. But the counter-offer can also be refused too, all right? There's no obligation. Now, in an auction, it doesn't work like that. It works on the basis that the auctioneer has consideration to sell the goods, not at a fixed price, unless there is a reserve on the goods. But if it was worth £100 and sold for 50 pence, that's the nature of the deal. If, on the other hand, it was worth 50 pence and it's sold at £200,000, that also is the nature of the deal. I had a friend of mine who went to an auction and bought some vase. He didn't buy the vase. He saw somebody buy a vase and he walked away and he thought, I thought that vase, that could have been worth a bob or two. The auctioneer sold the vase at around about £150. It was a Ming vase. So start putting many zeros after it, that was the true value of the vase. So it doesn't matter, okay? And the point I'm making, there's the counter-offer is there, but a counter-offer can be refused. So when we look at acceptance, we have definition and we have rules. So an unconditional asset to all terms, you agree the terms to those goods. You agree that the offer must be clear and transparent so it's understood. It must be accepted by the authorized person. So, okay, I don't think it really happens quite so much now, but it did. So people would engage in buying products. And what happens when somebody who's under the age of 18 engages in buying a product? So example would be a mobile phone. I buy a mobile phone and they buy it with a company online. Now, okay, one thing I would say here, and we don't talk about it in this module, but there's distance selling. And there is distance selling on the internet, which terms are very different, although some of them are underwritten within the Consumer Rights Act 2015. But distance selling gives you more options as a consumer. Nevertheless, when we're looking at buying something, you've got to have legal authority for buying it. So if you buy a telephone and it says you're entering into a commercial agreement, you must be 18 or over. If you're not 18, you can't engage in that contract. Now, obviously, you can look at, there are areas that might come into which could be criminality, and then unfortunately the parents might have then responsibility if it's a son, daughter, etc. The offer must be open. Okay, it can't be a closed offer. It must be open to the individual, and then for that person to engage in. And rules are they must be communicated, words or actions, not silence. My bottle of water. You're very keen on my bottle. You've been speaking all morning about my bottle of water. You photographed my bottle of water this morning. You 50p? I paid £1.50 out of the drinks machine just a short while. I know he's had a sip, but it's okay. I'm happy to have this. So you have this £1.50, okay? But I say, okay, you don't have to say anything, but I'll accept that you're buying it. Wrong. For an offer to exist and for it to be accepted, silence cannot prevail. If one of the parties is silent, there is no contract. Both parties have to agree. Okay? Not by necessarily nodding either, okay? Because some people nod all the time. That could be a bit of a problem. So it has to be very clear, and the actions have to be consistent with what's agreed. Now, exceptions to the rules of the communication, as I say, the need to communicate can be waived, and we have Carlisle's case. And Carlisle's, which is obviously where we're looking at the carbolic smoke ball. They didn't need to communicate any further because they put money in the bank, so therefore there was an offer, and it could therefore be accepted. And then we look at the posting rules. There's no need to necessarily communicate because it's by an action, and the acceptance occurs on posting. And it must be in contemplation to both parties from the outset. And please understand this. When you enter into buying something, in a case today it's slightly different because we buy things on the internet, but 15 years ago it wasn't like that, or even 10 years ago it wasn't really quite like it. Even 5 years ago people were a little bit skeptical about it. People would buy things, but they would buy things and they would agree to it, and it would be purchased, it would go through the post. And so when something is put through the post, it's agreed by the parties, and the courts view this from the outset. The postal rules will apply in every single contract, any contract, unless both parties have acknowledged from the outset that they do not apply and must be agreed by both parties. As I say, the letter doesn't even have to be received for the acceptance. Its acceptance is when the one party sends it. Yeah. No, the fact that if I'm saying to you, if I say I'm selling my bottle of water for 50 pence, okay, you write to me and say, buy that bottle of water for 50 pence. The minute you put it in there through the letterbox, we've entered into a contract, okay, and we've got a case on this a little bit later in our second part with the car, with the spider car. So, consideration, the fluffy stuff. You'll hear me call it this way because it's kind of if you make an association with something, and I call it, and the diagram I'm going to give you gives it like a cloud. And consideration is in every contract. What is consideration? And this is where jurisdictionally things tend to split. So if you are from outside the UK, you won't have this necessarily in a contract, but you do have it in England and Wales. Consideration is the definition, it's defining point. The price paid for a promise. Not generally binding if the promise amounts to nothing. And I've got a table on this which we'll go through. It must be benefit, but it might also be a detriment. The fact that I am selling this water for £150.99 might be to your detriment, but nevertheless it is still an offer and it is still valid. it would be your choice if you were to take it. A valuable consideration is in the eyes of the law, may consist in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given or suffered, or undertaken by another. You've got to go into, and this is why I say, and why you may hear, you go into your contract with your eyes open, not your eyes closed. This time last year, I think it was this time last year, I was with a cohort of students, probably similarly your group, but your previous cohorts. And it was at this point, and I said about Facebook. You've entered into a contract with Facebook. How many of you got Facebook? And all the students put their hands in the air and they said, well, okay. I said, do you know what you've entered into? And everyone's going, well, yeah, I can do the X, Y, Z. Yeah, but do you really know what you've entered into? Who owns the information? Not you. Who owns your photographs? Not you. You've assigned those to everybody. And what happens if there's a data breach? And of course, what happens? Cambridge Analytica last year and Facebook. And there was a real turnaround. It was interesting. We were talking about it that session. At the weekend, data analytics came out. So you've got to be very mindful. Go into a contract with your eyes open. Because you didn't see something, because you didn't read something, because you didn't understand, is not good enough. Remember the reasonable man test. If you enter into a contract, you should have it's not about understanding that if I enter into a contract with somebody, it isn't because I have to go on the acceptance that they've got to have such a good understanding, they're absolutely clear about what they're doing. They're doing it for their own reasons. But providing there's an offer, there's consideration, acceptance, and an intention to create a legal relationship, then it may be binding. It will be for the courts to determine otherwise. Consideration must move from the promise, so it can't be passed. Okay, so if I go back to my, so what we're dealing with here, it must move from the promise. So I promise to sell, I'm actually saying, I'm selling this bottle of water for 50p. And you say, I'll buy it for 50p. The promise has moved from me, the consideration. It goes from the promisee to the promisor. Consideration must not be passed. Let's say it comes to the end of the session. And you say, well, you're selling that bottle of water. I've got 50p. I say, it's gone. It's finished. Shutters are down. That's past consideration. Past consideration is not good consideration. Therefore, no contract. Consideration does not need to be adequate. I'm selling this for £250. It's going more and more. I don't think I'm going to get a buyer today. But therefore, it doesn't matter whether it's adequate or not. Consideration must be sufficient. It must be agreed between those parties. So, consideration is at every stage of the contract. I offer to sell my water, my consideration. You decide to buy it, your consideration, acceptance. You must hold on to this. No consideration is generally unenforceable. If somebody bought something without the consideration or engaged in a contract without that consideration, it may not be enforceable. And a promise does not need to be supported by consideration if it is contained within a deed, i.e., as we started from the outset, a property, or if you're engaged in a bank loan or getting a card where you're going under the Financial Services Act. You've got legislation that covers that, so it's slightly different. Simple contracts, not made by deed, require proof of consideration. Go back to that case right at the beginning of today's session. So, there are two types of consideration. There's executory consideration and executed consideration. So what is executory consideration? Well, parties exchange promises to do something in the future, e.g. the bilateral contract, paying for goods when delivered, and issues arise from a party not carrying out their promise. So they've agreed to do something, and that consideration breaks down. That contract may fail because one party has failed to do something. Interestingly, you could be looking at the wider terms. Now, there could be, and somebody says, well, I ordered something by an online site, and it was delivered by a courier, and they say they will deliver it to your house. And what I saw was they drop-kicked it over the fence into the back garden and put a note around the back that said, we put it round the back of your house. Or there's a really good video, I don't know if you've seen it on YouTube, It was last week, I think, where a delivery company was delivering something which was, I believe they were quite breakable, but and it was on the balcony, and they threw this thing right up in the air and missed, and it came straight out. Oh, we'll have another go. They go on, up they go, and we get in there and put a note through the door. So, the consideration of executory and executed considerations. So executed considerations where a party performs his part of the contract at the time of the agreement, e.g. paying for food at the supermarket where both parties have executed that consideration. So there's something that happens immediately and there's something that will happen in due course where a party has to engage in doing it. Now, this is the diagram. This is up on Surrey Learn. And I'm just going to go through it very briefly. Now, this is about consideration. You will see that consideration is not just mere puff. Mere puff. Now, mere puff comes from the carbolic smoke ball. That's the term that they gave. You know, so it was actually a contract. So it's not just merely something that doesn't exist. And here talks about consideration. It also introduces cases. But I'm just going to go through this very briefly. The starting point is there are clear rules associated with consideration. When you go on to Surrey Learn with this, I have put cases and details behind each of these cases so you can follow it through in more detail. But I'm just going to give you an overview. And for a start, consideration must be sufficient but doesn't need to be adequate. And courts will generally not judge the adequacy of consideration whether adequate value has been given in exchange for a promise. Remember, the very basics of a contract is one party's exchange of a promise to another and an agreement on that. And we've got cases there, which is Chappell and Nestle and Thomas & Thomas. We also say past consideration is not good consideration. If somebody made an offer, but that offer is in the past, you cannot reflect back on it and seek to execute it now. It's not an executory consideration, unless that's something that's agreed by both parties from the outset. A promise after an act has been performed is generally not enforceable. And again, we'll be looking at examples of that in our session, second part of today's session. Consideration must move from the promisee to the promisor. The promises must always provide the price of the consideration for the promise in order for that promise to be enforced. And we've got Tweedle and Atkinson. So consideration is critical. You know, it's all very good to understand that in order to engage in a contract, there must be an offer and acceptance of a contract. It goes beyond that. Consideration offer, consideration acceptance, intention to create a legal binding agreement. That is a contract. Now, I mentioned at the beginning that sometimes people may be engaged in a party of a contract. So a contract can go out external. We've got some cases on this, and we call this privity of contract. Privity of contract means that other parties may have an interest in a contract who may not have entered that contract to begin with. This is very limited in use, okay? It's not something which we see widely. So an example of this would be in the holiday industry. Some years ago, it was decided by the courts that if I bought a holiday for a group of people, that each person who went on holiday was entitled to have the benefits of the contract that was entered into. So if I bought a holiday for 3 people, all board, all food, all drink, all party, then it would be accepted that all of those people would be able to have all of those conferred to them. And if one of them didn't, or the accommodation was incorrect, then they will not have benefited under the contract. And therefore, the courts determined, and it started with the holiday industry really, for privity of contract with Beresford and Beresford, which was a case, that enabled individuals who didn't engage or were part of that initial contract or had consideration, essentially, but they could benefit from that. Now, you've got to be very careful about this, because privity of contract does not exist across all things. You know, I bought a car so you could drive it, and the car fails. Can you bring that case to court because you're driving a car I bought, but I'm letting you drive it? No, privity of contract will not exist. There has to be clear consideration, and it's for the courts to determine when privity of contract may exist. And there are some legislative aspects to it. So one might be an exception to the rule, might be a third-party motor insurance, or an agent who may have an interest in a particular good. So a house for sale would be an example of that. Or where there's a special relationship. But more importantly, by statute. where legislation is passed that says that it confers the rights to another party. That is the most complete way of doing it. And the travel package regulations enable privity of contract for individuals to benefit when somebody else bought a holiday that they went on, and therefore they could claim or make a claim to the holiday company if they didn't have those, whether it's the package or aspects of it that they should have done. Or it can be by assignment. That's directly if it's agreed between the parties. The court's view also is something else about a contract. A court says, look, and I think you have to understand this really carefully, at no point can it always be the case, because there may be instances where it may apply. But the general rule the courts have is that you cannot enter into a contract with a member of your family or within a domestic situation. Okay, let's be blunt. When you get married, okay, this is me as a lawyer talking to you, when you get married, you enter into a contract. Believe it or not, you do. When you sign the register, and you come out and you go, oh, and they say, right, you've got everybody out there, and you go off into the registry and you sign that. You're signing a legal binding contract. I agree to marry you, you agree to marry me, and we'll all live happily ever after. That's a contract. And if you breach that contract, we call that divorce. Okay, so that's kind of in a very crude term. And the courts believe that essentially that if you've engaged in a contract with somebody in your family, it can't be with the intention to create a legal relationship. It could be a brother and sister, or it could be a wider member of the family. So where an agreement is made in social or domestic context, the general rule relating to this is there was not I put here, the general rule relating to intention to create a legal relations, that the courts presume the parties did not intend to create legal relations. So from the outset, that would be the case. Yes?
What about like a prenup?
A prenuptial agreement, that would be that the courts have agreed that you've entered into a secondary contract which says that you have no rights that can be attained upon somebody's wealth, which is what generally a prenup will do. That's fine. But if you had a mother and daughter, that prenup's not going to exist. Okay. Interestingly, and again, even when we have a situation, and we've seen this being tested in the courts when individuals have now left wills, and we had cases where somebody might have created a situation to knock off one of their parents, i.e., kill one of their parents, and in order to get the wealth, and the court said no. And equally, when we have a situation where we've had a person who's died, and they've got a large estate, and they've left it, just like I guess the designer did last week to his cat, they've left it to a charity. And we've seen this case being brought to the courts, and the courts have said, no, that person had the intention of doing something. So this is really important that you understand this, that it's often very difficult to get the courts to engage that a contract has been created with legal intentions or a legal agreement, binding legal agreement between the parties. The presumption, of course, will be it won't be. So, when we look at a contract, there are two types. There are express terms and implied terms to a contract. Express terms are the written terms that you find in the contract. The implied terms are terms which a court may find to bring into that contract if those express terms do not apply. We'll see that in more generalised way when we talk about employment law, more so than when we talk about entering into a contract for purchase of services, etc. And then types of terms within our contract are as follows. We've got conditions, we have warranties, we have inanimate terms. So what we talk about, a condition, is a major term which is vital to the purpose of that contract. And I put here, it's a term that goes right to the heart of the contract. So you might have an agreement between two parties. One party is to do a particular action, but that action goes right to the heart of the contract. And if they fail to deliver on that, it can breach that contract. So it would be a condition. And that breach will allow the injured party to make a claim for damages and have the option to bring that contract to an end. It may, on the other hand, they may seek the court. It could either make it void or voidable. So when we say voidable, that means we may seek to bring it to an end, but we also may seek the court to make that contract be fully executed. See, if you've got somebody who's supplying goods, or they are acting, or you've got a contract for services and they haven't procured it in the way that it was expected, you might seek court action for them to do that. It's not within your interest to bring it to an end. You want that party to be enforced to act and fulfill their obligations. When we look at breach of damages, we'll talk about damages, not today in any depth, but when we talk about damage, and one thing I've said to you before, and I will say to you again, one of the things I will not be looking at you doing is being able to identify costs, quantum. I will expect you to perhaps, as we go on over the weeks, to talk about damages, Hadley Baxendale being the key case on this, but don't worry, that deals with remoteness of damages, and we'll talk about that later, not today, in a few weeks' time. But the position is that damages go there to support something. You don't get a bonus. Damages aren't bonus. Damages are designed to bring you back to the point you would have been before that damage or that breach of contract had taken place. And sometimes there may be consequential losses as a result of those damages, that somebody has breached a contract and as a result it's cost you more. Let's give you a simple example. Perhaps you've gone out and you've bought something, it's not worked, you were missold something, so you've gone back, you've made a claim, the shop has decided not to honour its agreement, so you've taken it to court, and you say, well, okay, it's not worked, clearly didn't work, I've got costs associated, driving to the shop, my time, that's what I mean by damages, okay? If brought to an end, the party must act quickly and within a reasonable time. A reasonable time is what the courts deem as being reasonable. So it would be in a very quick succession once something has been breached. Now, what about warranties? Well, a warranty is a lesser term to a contract. It's not fundamental, so it doesn't go to the heart of it. It's collateral to the main purpose, so it may have an important aspect to that operation of that contract, but it isn't fundamental to it. And a breach will allow an innocent party simply to claim for damages only. Okay, not necessarily for breach of contract. Now, a nominate, or what we say is immediate terms that are not classified as either conditional or a warranty, and that the remedy depends on a breach. So therefore, there has to be a breach for this remedy, which is a resolve to this contract. Anonymate terms do not replace conditions or warranties, but are simply a means of looking at the consequences of a breach rather than the intention of the parties within the drafting of the contract, i.e. what was agreed between those parties. Right, ladies and gentlemen, hold fire. We are going to take a break. The time now is 20 to 11. I'd like you back